My name is Sheila Polk. I serve as the Yavapai County Attorney, and I also chair the Arizona Criminal Justice Commission. It's my pleasure to be part of this presentation this afternoon, along with Judge Hancock, who is a Superior Court judge here in Yavapai County, and our special guest, Hannah Grage, who is an ASU AmeriCorps Vista volunteer. It is our hope that at the conclusion of this presentation, the audience will understand Arizona's new online portal for people to seek protective orders. I just want to give you a little bit of history about how we got to where we are today. This online portal was actually created by the Arizona legislature through legislation in 2018. That legislation took effect January 1st of 2020. So we now have 1 year of experience with our online portal. The legislation itself addressed a series of changes in the law, court rules, and the process to facilitate the easier creation and service of orders of protection. What's new through the legislation is that the court assigns the orders of protection for service directly to law enforcement or constables. The serving agent must report service to the court within 72 hours. And if unable to serve the defendant, they have to contact the petitioner within 15 days of issuance. Also, with this new legislation, our Arizona Supreme Court maintains the Central Repository for Protective Order Data. Its acronym is AZpoint. I see it kind of as Grand Central Station, where data is going in and data is coming out. The court now has a responsibility to transmit data on served protective orders to NCIC, which is our FBI National Criminal Information Center. And the goals of this legislation, as well as our online portal, are to automate the protective order system, to create legible, complete petitions, to increase the number of orders of protection that are actually served, and to expand the number of orders of protection that are entered into the FBI NCIC. In terms of the online portal itself, which is called AZpoint, there's 3 different portals. We call them portals, but there's 3 different sections depending on who you are. The petition portal are for those folks who are seeking orders of protection or injunctions. And as you will see later during this presentation, that petition portal guides the person seeking assistance through this online interview and helps them identify the proper type of protective order that they're seeking. Then there's the clerk portal, and that's where the court and the clerk of the court go when the petition is ready to be filed. They are armed with that petition number, and that ex parte hearing will be set and will occur. And then if the judge does issue a protective order, then the 3rd phase of this portal is for service. And that's where the serving agent can find the document that needs to be served and reports back with respect to how service is going. I mentioned AZpoint, the Court Protective Order Repository. AZpoint holds now statewide data regarding all the petitions filed, withdrawn, granted, or denied. AZpoint assigns service only for orders of protection, not for the injunctions. You'll hear a little bit more about that during this presentation. And then through AZpoint, the protective order, the data regarding protective orders are transmitted to NCIC, which is really important for law enforcement. If law enforcement doesn't know that there's a protective order out there, they are not in a position to help in protecting those who are seeking the court assistance. And now Judge Hancock is going to give us a little bit of a brief journey in history regarding protective orders.
Thank you very much, Sheila. My name is Sully Hancock. I'm a Superior Court judge here in Yavapai County. I'm also the presiding domestic relations judge. Protective orders come to domestic relations judges or family law judges. We do all of the orders of protection. What you're seeing on your screen now are the statutes and injunctions against harassment normally go to civil judges. It is a civil process for injunctions against harassment. It's not a family law case. So those go to civil judges. What you're seeing on your screen right now are the statutes that apply to orders of protection, emergency orders of protection, injunctions against harassment, which we'll touch on, and we're going to touch on all these later, and the injunction against workplace harassment. And all of these statutes are governed by the rules of protective order procedure. So we have the orders of protection. So one of the important things, and I saw a question on this pop up on the screen, orders of protection, you have to have, there's a relationship test. So you have to have a special relationship plus domestic violence to get an order of protection. What you're seeing on your screen is that it's limited to special relationships. So it's married, formerly married, if you're living together, you have a child in common. It doesn't go past grandparent and other. So other means if you're boyfriend and girlfriend, that kind of thing. But there is a relationship test that you have to meet in order to get an order of protection. As a judge, you have to find that there is reasonable cause to believe that an act of domestic violence has occurred in the past year or is going to occur. Injunctions against harassment has no special relationship, and it has to be a series of harassing events to a series of acts or harassing events. This is where you find the neighbors against each other. We're seeing more of in family law, which is troublesome, and there's legislation right now or rule changes right now. We see a lot of new boyfriend with father, husband, and then wife wants to get an injunction against harassment against new boyfriend. There is some new rules that I've seen coming up about those cases coming up into the family law case. But mostly we see neighbor against neighbor. Sometimes we say these, and this is going to come up later in the workplace, but the standard for this is reasonable evidence that the defendant has committed a series of harassing events or at least one act of sexual violence against the plaintiff in the past year, and good cause that there will be great or irreparable harm that would result to the plaintiff if the injunction is not granted. Injunctions against workplace, I told you this was coming up, and this is very broad, I think, but an employer can seek an order to prevent another from being on the premises and from committing acts of harassment against the employer, the workplace, the employees, any other person who is on the employer's property, a place. The employer has to show that there's reasonable evidence of workplace harassment by the defendant during the past year and good cause. We see these sometimes with a boyfriend of someone who works at the employer or a former employee that is mad because they lost their job. So that's kind of where you see a lot of injunctions against workplace harassment. Okay, all orders of protection and injunctions against harassment. I can't speak for anybody. The rule says you have to be seen expeditiously. In Yavapai County, we see you that day. You will be seen by a judge that day. What happens is you go to the clerk's office, and I think Hannah and I are going to walk through this. You go to the clerk's office, you get your order of protection printed out, and when it says ex parte, that means it's just going to be the plaintiff and the judge in the courtroom. So, and sometimes there are attorneys with them. We just talk to the plaintiff, and that's what ex parte means. We're talking to one party without the other party present. The defendant in an order of protection is entitled to only one hearing to contest the order. And they can ask for that hearing anytime within that 1 year. The plaintiff's burden person who is getting the order of protection is by a preponderance of the evidence. Our protective orders in Arizona stay in place for 1 year. So the defendant can ask for that hearing anytime within that year, but they only get one hearing. Protective orders can be issued by any court. One of the great things about AZpoint, I think, is how it's much easier for the plaintiff to fill it out, and it can be issued by any court. So our lower courts, justices of the peace, the municipal courts, and if you live in Yavapai County, you can go to any county and get an order of protection. One of the things I like about that is if a plaintiff in a domestic relations matter has had to flee or go somewhere else, they can get an order of protection in another county, which I think is a great addition to this. Protective orders take priority over any other orders, including parenting time orders. We are very careful to ask if there are parenting time orders in place. I know it's a shock, but sometimes in family law cases, people try to get orders of protection because they don't like the family orders. So, and there's a rule of protective order procedure where if you obtain an order of protection and there is a family law case, the protective order has to be transferred to that domestic relations judge for what are, I think, pretty obvious reasons. I can only speak for myself. I can't speak for other judges. I rarely put children on orders of protection unless there is flat out violence against the children, because that's in place for a year and there's another parent involved. So we can do that. We do put children on orders of protection, but you'll see the last of this slide says that it cannot contain provisions regarding legal decision-making or parenting time. So if you put children on an order of protection, the other parent cannot see that child or children at all. And so we're really careful to try and kind of suss out what's actually going on here. Is there a family law case? What does the family law case say? So we try very hard to make sure that make sure exactly what's going on.
Thank you, Judge.
You're welcome.
We are now going to talk specifically about AZpoint. AZpoint stands for the Arizona Protective Order Initiation and Notification Tool. This is this online portal. And this really is the focus of our presentation, is to introduce all of you to AZpoint. AZpoint is easy to find if you remember the name AZpoint. The website is posted here on the screen, www.azpoint.azcourts.gov. But all you need to do is Google AZpoint and it will take you right to this site. I'm going to give you just a little overview of what AZpoint looks like. Here is the home screen for AZpoint, and just a couple of features that I want you to be aware of as we begin this interactive session. One is what we call hover help. And so on every screen, I'm looking at the right of my screen, there's a question mark. When you click on that question mark, a box will come up and tell you what that particular icon is for. So every screen has the safety button. You can see that to the right. And then if you click on the hover help, it tells you to use the safety button in this website to quickly go to a different screen within your browser window. The safety button actually logs you out of this website and loads a Google search page within your browser. The browser's back button and browser history remain in the browser window. And then please read and follow tips and suggestions found within the facts section to understand more. During our interactive portion, we are going to show you exactly how this safety button works. And the good news is you don't have to save. It automatically saves whatever work you've done up to that point in creating your petition. Some additional features of AZpoint include a guided interview. I think this particular feature is wonderful because folks out there who need a protective order, they don't know the rules. And this is set up so that you can directly seek this protective order from the court. And so as you'll see, as we go through the AZpoint site, it's a guided interview where it asks you questions, and then it helps you decide, do you need an order of protection? Do you need an injunction against harassment? Or perhaps do you need the injunction against workplace harassment? The other nice piece about AZpoint is that all of the documents that a plaintiff needs to complete are part of this guided interview. So when you go through this process, you have everything you need to file. You will, at the completion, you will get a petition confirmation number, which becomes your key then for the next steps in actually filing it and seeking that ex parte hearing. But one thing that everyone needs to understand is that AZpoint is not an e-filing system. So evidence cannot be attached to what you're filing. And this is not a substitute for the actual filing of the document. The documents in AZpoint are stored for up to 90 days to allow for editing. So in other words, a person seeking help can start to create the petition. They can exit it, they can think about it a few days, they can revisit, and the work that they are doing to create that petition is stored within the system for up to 90 days. You'll see that in order to use AZpoint, you have to begin by creating an account. That account remains active, so you can revisit it after 90 days, but the petitions themselves will be purged after 90 days if they remain inactive. These petitions, this data is stored in the Arizona Office of the Court's Central Case Registry until the plaintiff requests action on a petition. And the court can't access this petition information until the user provides the petition confirmation number. So in other words, it's up to the plaintiff, the person seeking help, to decide, when am I ready to move forward? When am I actually ready to file? And so we are going to move now to this interactive portion. I am really excited about this. Judge Hancock and I have presented on AZpoint previously, but this is our first time with going live for you. We both felt it would be really helpful because many of you, your advocates, your law enforcement, you may be attorneys, you don't necessarily go to the site to seek for yourself an order of protection, but you are assisting or advising members of the public to do so. And so we thought it would be really, really helpful for you to actually see what this online site looks like and how one puts together a petition. We are very fortunate to have our AmeriCorps Vista volunteer, Hannah. Thank you so much, Hannah, for volunteering. Hannah has agreed to role play. So she's going to start with a little scenario. It's completely fictitious, but a little scenario to role play a person who is seeking a protective order. And she's going to go online, create an account. And then as she does so, she will have questions of Judge Hancock. You may all have questions as well. And so as you're seeing Hannah create this petition, we encourage you to go ahead and type your questions into the chat box. We want to be able to answer those in real time. And so Ray Chiara, our host, as he sees your questions, he's also going to jump in with those questions. So at this point, I want to welcome Judge Hancock and Hannah. And I know that Judge Hancock wants to start off. She has to make a few disclaimers, as our Arizona judges are required to do.
I'm so excited about doing this with Hannah because we're going to walk through this. I want everyone to know that the scenario that Hannah we're going to talk about here it is not necessarily a scenario that would be granted an order of protection or granted an order of protection. Every case has different facts, and there are standards and the judges have to consider before a granting of an order of protection. So I don't want, and my disclaimer is I don't want anybody out there to think, oh, that's my exact situation and I can get an order of protection based on those facts. The second thing that I wanted everyone to know is, I feel like this is obvious, but I wanted everybody to know that when you're filling out your order of protection, there's generally no one there advising you. If you have an attorney, they might be there with you, but it's not until you come to court and then get in front of a judge that a judge will be there. We are doing this to show you how great AZpoint is, and we thought it would be, as Sheila said, we thought it would be so helpful to have a role play, and we have Hannah, thank gosh, to do it with us. So those are my in general disclaimers. So this is not a scenario that would get an order of protection or would not get an order of protection necessarily. Go ahead.
Yes, thank you so much. So to start, as Sheila Polk talked about, I'll just go ahead and demonstrate that safety button. So when you click it, it will go ahead and take you to a recipe. As Sheila was saying, the back option is still there. So it will still show that the AZpoint system was in the history. So it's certainly something that if you're using a shared computer, it's good to know that that's still visible, but as an emergency option, that is something that is good to know and good to see. And Judge Hancock, would you like me to go ahead and start by creating an account?
Certainly.
Yes, ma'am. Okay.
Perhaps Hannah, as you are filling out each, would you tell us what box you're in case we may have some folks who can't actually see the screen. So for example, you're filling in username, then you have to create a password, etc.
Absolutely. So to create the account, I did the first name, last name, a email account, username, password, and then currently just a security question. And so let's see here. And then the answer to the security question. And then the preferred language. And so we have registered, and it's asking us to click the link, a verification link to the email. So I do have, I created an email account that is just a test email account for this. And so I will go in and click the link that the AZpoint system is going to send me. It's just going to take one quick moment.
I'm going to jump in here, Hannah. It's really important. We're going to get to this point, but we can take orders of protection over the phone. We try not to do that. You'll see that you have to come into the clerk's office to get your petition printed out. But we, especially in the past year because of COVID, we have taken orders of protection over the phone. But there's an identification problem with doing orders of protection by phone. And so we will ask you some questions. So if you're not able to come into the court, we can do them telephonically. We try not to do them telephonically because we don't actually know who the person is. And when you come into the clerk's office, they're going to ask you for identification. If you're calling in and we can get it done over the phone, we also have video and Teams and that kind of thing. But we will be asking you some questions to ensure that it's actually the person that filled out the petition for order of protection and not somebody else trying to be the person that they think is filling out the order of protection. Go ahead, Hannah.
Perfect. So I will go ahead and start a new petition. And so it's just going to ask for plaintiff information. So that for this particular circumstance, We're saying that my boyfriend and I have been together for many years and have a shared daughter together. So in this particular circumstance, he's grown increasingly abusive toward me, both verbally and physically, and I am afraid of this particular person and what's going to happen if I try to leave him. And I also want to make sure that my daughter is protected. But as Judge Hancock said, that might be a different circumstance depending on. I really want help, but I'm afraid of what to do. So I am looking to file an order of protection. And we would pass the relationship test. We have lived together, are in a current relationship, and have a shared child. And so based upon the account, it does autofill some information, the first name, last name, and then we're just using some miscellaneous information. None of this information is real or relates to a real person. So that is good to know.
And I'm going to jump in here again. If the cell phone is a very important part of filling out the order of protection, that goes onto an information sheet. It does not go to the defendant or anyone else, but that is the number that the law enforcement will use to contact you. So that's the number if they can't get it served within 15 days. That number also, I feel like most law enforcement is pretty good about calling the plaintiff once the defendant has been served. So that's a very important part of filling out the order of protection.
And for this question, the plaintiff email address restriction keep confidential. For people who do not know, would that then show up on paperwork or would that not show up on paperwork?
It shows up on, and I know I'm trying to, I see it every day, so it's hard for me to describe. There's a separate plaintiff information sheet, and it has some of the defendant's information, but it has the plaintiff's information on it as well, and that does show up on there. And you can say yes or no. If you want to keep it confidential, it's not going to show up. If you don't want to keep it confidential, that will show up on the plaintiff's information sheet. It doesn't show up anywhere else.
And Hannah, what are you're in? Looks like you're on the next section now, so you're filling out address here.
Correct. Perfect.
And the plaintiff's address is automatically kept confidential. It doesn't come through on the petition. So the address is automatically, the home address is automatically confidential.
And now we're filling out the name of the workplace and the work address. And it shows that there's an option to keep that confidential as well.
There is. You should know that when you come into court, I sometimes on the record ask where they work. And the reason I ask where they work is, at least in Yavapai County, we have, a big hospital, we have the Veterans Administration. Sometimes the defendant works at the same place. And I don't exclude people from hospitals. We have one hospital here. So this is more of a rural county thing, I think. But I can't exclude somebody from going to the hospital if there's an emergency. But if you click the button that said keep confidential the work, it will not show up on the petition either.
And then we do have a question, Soleil, if you don't mind answering.
Sure.
We have a question about AZP participants and how they should use their substitute address. It's the address confidentiality program here in Arizona. Yeah. I'm not sure if you're familiar with that or not. I'm not. Sure.
So if you are in that program, it will not show up on the petition. And your home address never shows up on the petition.
Fabulous. And then we kind of discussed this. There's the option to protect a school address, either for yourself or another person. That's what I'm filling out right now. So hypothetically, if there's a child involved, you can list the child's elementary school or middle school or high school. And then what sorts of addresses are eligible for the additional address to protect?
I just want to say about the school, you cannot put a child on an order of protection and put the school on there. You have to be a little bit careful if the defendant has more than one child that's not at issue, is not the child of this relationship. You can protect parents' homes. I've had that happen. There are, you could put anything you want on there. You have to be a little bit careful about it, about putting too many addresses on it. I don't see so many other addresses you want to protect. It's usually like the grandparents or some other relative that's in brothers, sisters' addresses that who are involved in the order of protection somehow. So you can put those kinds of things in here. Other ones are, I've had relatives that live in New York, and that's obviously not a great address if they're out of state to protect.
And before we move forward, Hannah, we do have some things that are in the Q&A section that I would like to address, if that's okay.
Absolutely.
Great. So the first thing is there's some clarification, Judge, that the plaintiff's address information is confidential. So that is instead. So that's great. I just wanted to make sure that's clarified to everyone.
The plaintiff's address information never shows up now.
Great. And then there's also another question. Can the address, email address, and phone number be protected just like the home address? And I think that's referring to the APC.
Yes. And you can see up here where it says keep confidential, you can say yes to the cell phone, yes to the other things. I am not sure though, because we don't see it anymore when it goes right to law enforcement. The judges don't see it anymore. So you'll see up here where it says, if this service is available, can the court text you? I'm not sure why they're saying court, except that the only time I've experienced that issue is if the law enforcement calls the court for some reason about the order of protection. I had a call from law enforcement this morning on an order of protection. And the issue in that order of protection was that I had ordered that the defendant not possess or purchase firearms or ammunition. And apparently this defendant had a kabillion rounds of ammunition. And they would have had to log in each piece of ammunition. So sometimes we do get calls from law enforcement about some of these issues, but if you don't want your cell phone to be on there, it doesn't have to be on there. You have, actually, that's not true. You have to put a cell phone number on there for the 15-day requirement. Otherwise, everything else is confidential, and we never, ever, ever see the plaintiff's address on the petition. That's part of that legislation that was nice for the courts. Previous to that, we didn't have this system at all. So people would be filling out the petition and you would have to put your name in the top left-hand corner and people would put their address on it. And we're not allowed to modify a filing after it's been filed. So it was really frustrating for people seeking orders of protection. So the plaintiff's address does not ever show up on a petition.
And then I have one more question before we move forward. We have a question that says, many times I have clients that fall into many of the categories of the relationship drop-down box, but share some children. If the petitioner shares children with the person whom they are trying to get the OOP against, do they have to select the above other options?
No. I think you can, but if there's, you could put the multiple, if you have children or non-children. So if the plaintiff and the defendant meet the relationship test, then that's fine. You can also try to protect children that are children that you don't have with the defendant. That's fine. I think, is that the question? Yeah, I think you can only click one.
Yeah, you can only select one, and they're
Yeah.
trying to ask what would be the best selection for them if they
Oh,
share
as long as
children.
you meet the relationship test, it's fine. And also know that when you come before the judge will ask you some questions. I mean, it's not, at least in my court, like I said, I can only speak for myself, but I will ask you those questions. And if you put the children's names where they go, and if their last name is different, I will know and I will ask what's going on. There's not a better relationship test for any of these. You just have to meet the relationship test.
Great, and I think we can move forward, Hannah, if that's okay with everyone else.
Perfect. Just taking just a moment.
Yeah, and just one more question, actually. It looks like it just came in. Can you please clarify on the school addresses can't be a place of protection? This is not a relation to student. This should be for children or parent protected from another parent at the school address. Can you speak a little bit on that?
Yeah, I didn't say you can't protect school. You can. You absolutely can put a school address on there. What I said was, if the defendant has other children going there, not children of this relationship, but other children of another relationship, then you have to be a little bit careful. And I always ask that question. It's not that the school can't be protected. Most of the time, if there's a child on an order of protection, the school will also be protected on the order of protection. But as I said, we're very careful about putting children on orders of protection. It's kind of a hot button issue right now because of the school shootings and all of that goes on. So we try very hard. I also tell people when they come in on an order of protection with children on it, I tell them you can file a family law case, and there are things you can file into a family law case that will get you immediate attention from us as well.
And Hannah, before you start typing, will you scroll up to the top of this page? I want everyone to see how she is progressing across the top. So the far left, she completed that plaintiff information. When she clicked continue and save, it then took her to the defendant information. And you can see there's a number of boxes across the top that she will be proceeding through before we get to actions, which is where then she can actually file. Thanks, Hannah.
Of course. So next we're on to defendant's name, which is the one I will be filing against. And then as Sheila had talked about, there's this little question mark button right next to for example, the defendant's date of birth. You can hover over it and it will give you a hint if the person who's filing is unsure about any question. It will give some more information just for clarification. So for example, in this question, if it's clarifying that the defendant's exact date of birth is not necessary if it's not known. Then currently we're just filing more information about the defendant, birthday, address, cell phone number, and then Judge Hancock, is the cell phone number and email address, will that be used to contact the defendant? Will they ever contact the defendant using this information?
They should not contact the defendant by the email or the cell phone number before he or she is served. That ends up being a little dangerous in my opinion, but they can use that to contact him if they're unable to serve, that kind of thing, so that they do have the information.
Fabulous. And then this next section is just asking for some demographic information for the defendant: race, ethnicity, sex, height, weight, eye color and hair color, things that are important for the agency that's serving the order of protection, so that way they can identify the defendant. And so that's just information that you can fill in. Next, this is also helpful, any distinguishing features, so that way that the serving agency, if they're looking for someone, they can look for super identifying features such as scars or marks. So judge, if they're, for example, surgical scars, birthmarks, things that you could place, do you have anything in particular that you ever recommend looking for, filling out in this category?
You know, it's really for law enforcement. I kind of want to go back to that cell phone and email. Law enforcement is very good about figuring out where people are, and if they call them, they're very, very good about figuring out how to get people to talk to them. So the law enforcement is very good. And in this situation, this is really for law enforcement. So it's very dangerous for law enforcement to go serve domestic orders of protection. The most dangerous kinds of cases are family law cases. And so this helps them make sure that they have the individual that they need to serve. And especially with the scars and tattoos, and if weapons are alleged in the petition or in testimony. So this is really law enforcement that is so helped with this kind of thing.
Fabulous. And then this next section is work information as well, which I presume is more assistance to law enforcement, where to find the person if the order of protection is being served.
Yes, and when the defendants, about to get to the defendant's work hours, this is all so helpful for law enforcement to try and find the individual if they're having trouble finding the person.
Perfect.
Now, one thing I'm observing is that none of these have to be completed before you can proceed. We're all familiar with these online interviews where you can't proceed to the next page until you complete every box. This allows the individual to fill out what you can, to skip ahead and then come back later and complete it. And Hannah's filling in here where the defendant can be located. Again, this is information for purposes of serving the defendant with the protective order.
Perfect. And these are things like best places and days at home, at work, or other places. So for example, in this scenario, perhaps the defendant spends all day Monday at his parents' house, and perhaps you know the defendant's parents' address or perhaps not, but at least this is information for the serving agency to know. So that way, if they're serving the order on a Monday, they know exactly where to find the individual.
And just so judges don't see this information, just so you're aware. That does not come to us.
And Judge Hancock, can I ask a question? It looks like there's been a couple of questions about the same idea of, can you update or can you upload or attach a police report to this AZpoint?
No, and let me explain that. Nothing attached to a petition for order of protection goes through, and here's why. Only the petition for order of protection and the order signed by the judge goes through the system. And the problem with it is this: the defendant is only going to get the petition and order, and that's what he or she knows the plaintiff has said against them. So it's really a due process or issue. So you can't attach any evidence. A police report is evidence. I sometimes have people come in with, 5 or 6 pages of handwritten or typed statement, that's not going to go. And the defendant has a right to know why he's being served with an order of protection. And so that's why the police report, some people say see attached, and that it's so the defendant knows exactly why he's being served with an order of protection. And none of that will be attached to what the defendant gets.
And to follow up with that, we do have a question asking, what can we do to help individuals get police reports to file? There has been a few times that an OOP was denied because law enforcement reports could not be obtained in a timely manner, or not being written, or the numbers were not sufficient enough for proof. So can you speak on that?
I can't speak for any other judge in the state of Arizona. Sometimes the law enforcement reports take a few days. I would say that, and Hannah's going to get to this, the part where you write in what happened, that's where you put it. It may or may not be granted. I don't know. It's really about, and Hannah's going to get to this, being as specific as you can in the body of where you can put, this is what happened to me.
Thank you.
Perfect. So on to the next section, it's just defendant additional information. In our particular case, we won't include any of this, but this is perhaps very important if you know any of these particular, if you know any particular information about these 5 little sections asking about whether or not the defendant has a history of drug abuse or alcohol abuse or anything of that nature. Now, Judge Hancock might be able to say more about this, specifically related to firearms and weapons, especially related to legal or illegal weapons. There might be a differentiation between these two questions about owning or having a firearm. For instance, in the case that we are demonstrating, perhaps this person has a firearm, but it's not registered or anything of that nature. Perhaps Judge Hancock, you could speak to the difference between the two questions, between owning and having a firearm or weapon, and what you do as a particular judge or any other judges you know when it comes to firearms and domestic violence cases you see as well.
Sheila, did you want to say something?
Well, I was just going to clarify that this particular section, it's asking about, is the defendant violent toward the police, a heavy drinker, on probation, parole, a drug user, mentally ill, do they own or carry weapons? This again is information so that this is about protecting the entity that is serving the defendant with this petition. I assume, Judge Hancock, that this information doesn't go to you. Is that correct?
I don't see it at all. The rules require judges to ask about weapons. What does come to us is there's a box, and I don't know if it carries over from here or another place, but there is a box you can check about weapons. And even if you don't check that box, we're required to ask about weapons. And I will always, there's a sheet that I get. I always write in if they are a prohibited possessor, meaning they have a felony and they're not supposed to have guns. I will write in and I always ask, have they been arrested or convicted of a prior domestic violence? But this is, and I do that so the cops also have that on my, or whoever's serving, have that on my order as well. But all of this, and we don't know if it's a legal gun or not. And what happens in my order is I will order that they not possess firearms or ammunition, and then I can order them to turn over their weapons to law enforcement within a certain amount of time after I issue the order. But I don't see any of this. And you know, whether they actually turn over all their, once I issue the order, I'm out. This is really for law enforcement and for their protection. And I will reiterate, if I think in testimony something else has come out that I'm concerned about for law enforcement, I will write it, and it'll be, I have an other category on the order that can be filled in.
Perfect. So then if a defendant's or a plaintiff's particularly concerned about their safety related to weapons, they should include that in the incident history, perhaps.
They can, and I think when you check the weapons, it does come up on the petition. And then the statute says, and I think one of the rules also says that it can be either in the petition or in testimony if you allege weapons. So it's kind of a break because it's so important. So even if somebody doesn't put it in the petition, they can allege weapons in testimony, and I can hear that testimony. So that's a little bit of an outlier, or otherwise it has to all be in the petition.
If we do not have any, Ray, are we good on questions or am I good to move on? Fabulous. Perfect. So next is the family court information.
Please fill this out.
Please. Okay, so it's just asking, do you and the defendant have a pending family court action involving maternity, paternity, annulment, legal separation, dissolution, custody, parenting time, or support? So I said yes, and it's asking in what county superior court. I'll say Yavapai. And what is the case number? I'll say I'm not sure. And then Judge Hancock.
Yeah, this is super important, and it doesn't have to be in Yavapai. It can be in another county. It doesn't mean that you're not going to get an order of protection. Any judge in the state can issue an order of protection, but it does have to be transferred to that county. And there are venue issues with family law cases and orders of protection. It doesn't mean you won't get one, but the rules provide that you have to transfer that to where the domestic case is, which a lot of people don't like. And I can understand that they don't like it, but we also have family law rules that we have to follow regarding venue.
Perfect. So if I said that my case was in Santa Cruz, then my order of protection would then be processed in Santa Cruz.
I would, if I issued it here, I can issue the order of protection, no problem. But it would be transferred to Santa Cruz, whatever judge has it in Santa Cruz County.
Perfect. So the next section, other orders of protection and other relief. Are there any other orders of protection between you and the defendant? Would you like me to fill this out as yes or no?
If there are some rules of protective order procedure where if there are, it's called mutual or competing orders of protection, there are some rules regarding that. Just fill it out accurately.
Correct. Firearms because of risk of harm. Should the defendant be ordered not to possess firearms?
I think this question is where it comes up on the petition.
Perfect. And then the option to protect an animal. Should the defendant be ordered to stay away from any animal that is kept or held by you, the defendant, or child that lives with you or the defendant?
That's actually a new part of the legislation protecting the animal.
And then are there any other requests you are asking the court to make to protect you from the defendant? What are some examples of other requests?
Oh, Lord.
Hannah, go ahead and click yes and show us what
shows
happens.
up. Right. And
Okay,
so then
it's
you
a
list,
fill-in
you
box.
can list the requests. I've had some cases where the plaintiff was disabled and they were worried about the defendant taking whatever medications they had when they came to have their one, we'll talk about this, I'm sure it's going to come up, their civil standby. I have had individuals that were worried about a whole host of things that the defendant would do. I don't get other requests that much except for the order of protection, but it could be anything.
Am I okay to move on?
Sure. Yep.
Fabulous. Thank you. And then here's the option to add another person to the petition.
And
So
Ray, I saw a question when we first started about another person. These can be children. There was a question early on about other adults. Do you see that question, Ray?
Yes, let me bring it up right now and I'll ask it. Many times we see OOPs that have adults as additional protected parties. Do other jurisdictions have this issue?
I think we all have seen this issue. Sometimes they're disabled or they're caregivers for another adult, but we also see this, and I personally never do this. If it's another adult, then the other adult can come in and get an order of protection if they wish against the same person. But people do put other adults on the order of protection. I've seen other judges grant those. There can be a whole host of reasons that people want other adults on there. I personally never do it. If that person is an adult themselves, then they can fill out a petition for order of protection themselves. But I have seen that. And I've heard other jurisdictions having that problem too.
perfect. Would you like me to demonstrate what would happen if I were to add a child to this petition?
Sure,
or-
sure.
So we'll just ask for the person's name.
And I have another great question here. And this could be both for Sheila and for Soleil. We have, is an advocate able to assist somebody filling out this form? And if so, would they need any specific training outside of this presentation here?
Go ahead, Sheila.
The answer is that advocates are absolutely able to assist. And in fact, we encourage that. The training for advocates is pretty much what we're doing right now. And Ray, this is being recorded. Does that mean that other folks can watch this recording at another time? Okay.
Yes, that is correct. Yep, we are recording it and it can be distributed later.
Okay.
And we, in my courtroom, I have pamphlets from almost all the agencies in Yavapai County. I always ask plaintiffs, have you sought the services of an advocate? And I tell them, please get an advocate. They can help you through this process. And we give them all the pamphlets we have. And I've been known to say, promise me when you leave this courtroom that you're going to call one of these numbers and get an advocate. We love advocates, and that really they can help people a lot more than a judge can help people. Just getting in touch with them, and absolutely we encourage them to get an advocate to help them with all of this.
And I have one more question here. It's asking about the exclusive use of the residence within the OOP. Can you explain about that?
Yes, I can. So if people are cohabitating and they want, and then you can get exclusive use of the home. I always, and you don't have to do this, but I always put in my orders of protection that the defendant shall not go within 500 yards of the residence. If they're both cohabitating there, that's basically exclusive use. But they can request exclusive use of the home, and you can order exclusive use of the home. The only trick with ordering exclusive use of the home is if the defendant asks for a hearing, you have to have it within 5 days. Normally, if a defendant asks for a hearing on an order of protection, you have to have it within 10 days, which we do. But exclusive use, you have to have one within 5 days. So I don't see very many exclusive use. I see them more in temporary orders in family law cases than I do in orders of protection. But yes, you can ask for that, and it's somewhere in here. I think it's in the next screen, that you can ask for exclusive use, yes.
And then it looks like another question popped up regarding advocates. Is there any limit to advocates, such as therapists, social workers, DD shelter staff, etc.?
I mean, that would be up to the therapist if they wanted to assist you in filling out. Anybody could help you fill this out. But that would be up to the individual to decide whether they wanted to help you fill it out.
Perfect. Are we comfortable with moving along from the additional person?
Yes.
Fabulous. Thank you. And then finally is the incident history. So this is where I will be asked to fill out information about the incident that took place that, to my understanding, is what triggered my desire to receive or to file for the order of protection. Judge Hancock, I know, and Sheila, you both spoke about this a little bit. The incident report does require a lot of information. Judge Hancock, I might ask you to speak about this a little bit more. I know that there are some limits about how much or not limits, but you need to fill out lots of information in order to then speak about that when you're receiving the order of protection. Like if you can only speak about in court what you file in terms of the incident. Perhaps, I don't think I'm wording that correctly.
It's okay. It's the more information we have here, the better. You have to select a date. That is because, as I said earlier, I have to find reasonable cause that an act of domestic violence has occurred in the past year or will occur. So you have to have the date. You just put in April 10th, I see that, so that I can ask what happened on April 10th. And you're going to put the description of what happened. And so when you come into my court, I see that something happened on April 10th. Why don't you tell me what happened on April 10th? And then we'll discuss what happened on April 10th. And then if there's other incidents, you put them in. You can put as many incidents in there as you want. I would say that the more information you can put in here, the better it is for me and to know what's actually going on in your case. Sometimes people will put in, in 2007, this happened. And I understand that. And I want everyone to understand that judges understand that this has probably been a long cycle of the circle of the domestic violence. We understand that. We have to do what the law says we have to do. So I try to be very careful with plaintiffs and listen to them, but we have to follow the law. So, you have to be able to put the date in there. One of the things about domestic violence victims that I've learned over the years of seminars and that kind of thing, a lot of domestic violence victims have trouble with dates and actually putting together which incident happened when, which, we know. And so that's one of the reasons there's this estimated date next to it. So sometimes they have trouble with the timeline, which is fine. But put all of your information. What I would recommend is putting all the information in here that you can remember, and then the judges will go over it with you in court and ask you some questions and try to put the timeline together. That's what I would say about this part. And this part is truly the most important part of the petition. Sheila, did you have anything on that?
I was just going to say that this information, Judge Hancock, does go to the judge, correct?
Oh, yes. No, this is what we actually, the actual petition for order of protection is only a couple of pages long. And this is what we rely on to make our findings about whether or not an order of protection is going to be issued. This is what we rely on, this description of the incidents. And this is what we rely on. So that's why I said it's important to fill it out as descriptively as possible. The date is important. So yes, this is what we get.
And
so go ahead, Hannah.
So if I'm filling this out and I tell you, oh, well, and I leave out important details in my incident description, or if I describe one incident, but then I get in court and I want to talk to you about a more serious incident that happened 2 days later. Am I allowed to describe those incidents to you?
You can testify to other incidents, but this is what I have to base my order on. I can't go outside of the petition because this is what the defendant is going to get. This is what he's going to be on notice as to, this is what you alleged. So when I make my findings, and I developed a whole script for these things, but this is what the defendant gets. So this is what he is going to see that you alleged as to why the order of protection was issued. So I have to rely on this. That's why this section is so important. And sometimes, people want it, plaintiffs sometimes get off track and all of that, which is fine.
We do have
And I
a few
don't know
questions
the
in this
answer to
section.
this.
Go ahead.
I don't know the answer to this. Is there a limit to the number of words or characters that one can put into this section?
There is, which is kind of frustrating. And that's why people sort of attach things. So it's not that a judge can't for example, this incident where she says there was too much money on groceries this month. He got really mad and called me a lot and then pushed me against the wall. And things got worse. I was worried about him lashing out at the child. So they went for a walk, and then, all of this other stuff happened. It's not that I can't take more testimony about this. I can. But I think it is limited as to the number of words. So I can take more testimony about what happened here. She says that he hit and punched me a number of times. So you can continue this incident on another. You could put the same date and continue it in another space. Go ahead, Ray.
We do have a few questions in this section specifically before we move forward. One, do we have to have a minimum number of incidents to file? It looks like you can just put one, but.
No, there's no minimum.
And then will the defendant see any of these incident histories that are being reported in this form?
Yes, he will get this. Yes, absolutely.
Also, is it appropriate for them to basically copy and paste the information from their IR that they've received from their police department? The incident report?
I don't care how it gets in there, just put it in there.
Great. And then there is some clarification that talks about that there is a maximum of 10 incidents that they could put in this form with 5,000 characters per incident, so 50,000.
Oh.
If additional paper can be added if the plaintiff wants to add more. So there can be more.
No, you can't add additional paper because that's not going to go to the defendant.
Let's see. I think these are all the questions for this section, and then there's other questions we'll talk at the Q&A part.
Okay, so if we are ready to move along, then we'll go to the action section. And so I may ask for some guidance here. This looks like the section where you review to ensure that all of the information is correct. And then if I continue scrolling, it asks if I'm ready to make this court ready, at which point it would move forward, and then what would happen after I confirm that it's court ready.
Sheila, my understanding is you make this court ready and then you can come down to court.
Yes, we are going to, if we are court ready, then we're going to end this interactive portion and go back to the PowerPoint. But Hannah, if you would scroll back up, I want, at what point, at some point, this AZpoint has determined that what you are going to get is an order for protection.
Yes.
So if the facts had been different, depending on the answers to the guided interview, would it have taken her to
No.
injunction against harassment? Okay,
No.
Go ahead, Judge.
I don't believe it does, because it doesn't, I don't think it reads what you said. Now, if you hadn't put the relationship test if you didn't qualify under the relationship test, I don't know if you have to select one, otherwise it won't let you continue.
Okay.
And I don't actually, Sheila, I don't know. Hannah, can you scroll down further on that? On the relationship test. Oh, go down to the bottom of that slide, that section. So it says petition for order of protection. I don't actually know how you say that.
So I will like to say that we do have Kay Ranowski on this, and she's an expert on this site, and she did want to offer some information. She said yes, if she had selected other at the beginning, she would have to set her on her track for an injunction. So that's where that would selection would be.
What do I know? Perfect.
And can I just say, Kay, thank you for joining us. Kay actually is part of the team that created AZpoint. So I'm so glad that she was able to join us. And in particular, that's awesome. So it guides you then, depending on early answers, toward an order for protection or an injunction. And
great.
Then where things are differentiated is if it's an order of protection through the system itself, it will be transferred to the serving agent. So in other words, the plaintiff seeking an order for protection no longer has to worry about getting it served. It's going to get served once you go ahead and file. But if you're seeking an injunction against harassment, the plaintiff, you still have that burden of making sure that it gets served and making those arrangements, and a fee can be charged. So I think we are ready. Are we ready then to end our interactive? Oh, one more question, Ray, go ahead.
We do have one more question, but we can leave it as all of us facing. So we do have a question that says, once you make the petition court ready, we haven't been able to go in to make any corrections or changes. Is that correct? And it looks like there's a review section before you hit court ready that you can make those changes. But once you select court ready, there won't be any edits. Is that correct?
I believe that's correct. And Kay, if that's wrong, speak up and let our audience know.
We have our expert.
And then at this point, Sheila, you can go ahead and share your screen again and finish the presentation. And we do have quite a few questions here to end.
All right, so let me just say, excellent presentation by Hannah and Judge Hancock. Hannah, you did a great job. And I hope everyone appreciates how lucky we are to have Judge Hancock join and share. I think most of you know that judges are not always so accessible. So I think we have this unique situation to have Judge Hancock make herself available for this entire presentation. So the next thing that happens is that now that petition is ready to be filed. And let's see, I'm not advancing. Oh, wait. All right. There we go. So Judge Hancock now is going to walk through, this is really the clerk portal. And Judge Hancock is going to walk through the next few screens to, I see it's already 1:16, so we'll have Judge Hancock take us through this.
I'm going to go really quick. So what happens now is you come to the court, and the clerk of the court you have to have your number ready, and then they will put it into the system, and then they will print the petition out. The case is then created in the case management system, which in Yavapai County is AJAX. And then number 5 is kind of important. We still accept the paper filing. There are ways to get that into C4 and all of that. And then 6 says an ex parte hearing is set. And there can be, like I said before, virtual hearings during COVID or telephonic hearings. We see all of you the day you come. No matter what time it is, we will take breaks from our hearings. And I do 80% of them in the Prescott side of Yavapai County. So if we have to take a break, we will. We see them all the same day. And so this is what we were talking about before about service. They automatically, I call it the whoosh. They automatically go to law enforcement or constable for service. They're supposed to serve them within 72 hours, and for orders of protection, there is no fee. For injunctions are very different. The petitioner has to serve the defendant in an injunction against harassment, and they must do that within a year of issuance. And if they hire a process server or they go to an agency, they can charge a fee. Service for the order of protection, as I said, it goes through the portal. And as we said on the other slide, they actually, the servicing agent portal, they have to get it in there within 72 hours. And then it's assigned to law enforcement. I believe it's, Kay can correct me if I'm wrong, but I believe it's still going by the zip code, the defendant's zip code to whatever servicing agent is there. And then the servicing agent portal creates the petition and OP for service on the defendant. And again, if law enforcement is unable to serve the defendant within 15 days, they must notify the petitioner, and they must continue to try and serve the order of protection for a year. And injunctions against harassment, again, this slide, they have to pay an injunctions against workplace harassment. They have to arrange for service. And this little parenthetical is kind of important, unless there's a dating relationship or sexual violence. So there can be this dating relationship issue, and I think the legislation was made for this problem as well. If you don't quite meet the relationship test, then you can get an injunction against harassment and they will serve it for you. Again, the proof of service within 72 hours via the service portal. And again, the Supreme Court is the central repository and registers all of them with NCIC. NCIC is what the law enforcement bring up on their screen to see if someone has an order of protection or an injunction against harassment.
So that's really an overview of AZpoint. This data, Kay just provided it to me earlier this week, so I was able to add it to this presentation. This is really interesting. This is the data from the entire year of 2020, showing us how many protective orders were issued altogether and the types. So you can see that it goes through it month by month from January through December, that the total number of protective orders issued in Arizona was 30,571. Of those, 7,276 were injunctions against harassment, and that's the IAH. The 334 were injunctions against workplace harassment, and then 22,961 were orders of protection. So that's for the state of Arizona. And then the next screen is showing us how many folks are using AZpoint, our online protection system, and again, month to month. So we still have that total of 30,571 protective orders issued. The bottom line is that 14,108 were issued via paper, the traditional way, and then 16,463 were issued through the online portal called AZpoint. It's interesting, if you look month to month from January to December, you can see that we started out January of 2020 is when this site went live. And at that point, more paper than online were being issued. But I'm pretty impressed that the month that it went live, we had 1,025 orders of protection issued, sought and issued through AZpoint. You can see through March that there were more paper, I shouldn't say orders, I should say petitions. So more paper petitions sought than online petitions. But then in April, which of course, by this point, COVID was pretty prevalent throughout the state, but in April, switched pretty dramatically where we had far more online than paper petitions sought. That maintained all the way through, it looks like November, and then in November, for whatever reason, the paper petitions outnumbered the online petitions, and then the same thing through December. But at the end of the year for 2020, we had slightly more, by about 2,000 more online petitions than our paper petitions. I think it'll be really interesting moving forward into 2021 to see what the data is with respect to this online portal. And so just in terms of wrap up, these are some of the enhancements that AOC is still working on. I noted here Spanish translation, but I believe that has already occurred. Kate can correct me if I'm wrong. But additional features include allowing the serving agent to add notes about service attempts and the plaintiff notification system. And then how can law enforcement and victim advocates help with this process? I think first and foremost, help spread the word to the public about AZpoint. I'm pretty impressed that 16,000 individuals across Arizona knew about AZpoint in 2020 for something that just launched in January of 2020. I think that's really good progress, but we can still see that we have quite a few folks that were following the more traditional route. Using AZpoint avoids trips to the courthouse, especially during this pandemic. And there's so many features about this online portal that I think are just wonderful. It allows the victim time to prepare the documents thoroughly and accurately. That's only going to assist them when they are seeking that order from the judge. And then it allows the data to be transmitted quickly from the courts to CPOR, to law enforcement and constables, and back again. One thing that we always want to urge victims and those who are working with victims is that you really make sure that there's a safety plan in place. As you can see through this system, once the order is going out for service, there is a high priority in getting that order served. And so before we take that step, just make sure that our victims are prepared, that they have their safety plan in place.
And Sheila, I just want to jump in. There is a new part of the protective order procedures, and I always do this in my cases where a judge can order that the protective order be suspended for 24, 48, or 72 hours if the plaintiff needs to have that time to get a safety plan in place or to get somewhere or that kind of thing. So that's a question that I always ask too during the protective order hearings.
Wonderful, thank you. And then if your client wants to apply for an order of protection, these are just some tips. You can, as we've said in this presentation, assist. You can sit down with them at that computer or smartphone, at the library, at a shelter, wherever. You can assist with this guided interview in the AZpoint petition portal. Help the client obtain a new email address if necessary. Make sure that you're discussing with them computer safety, whether the email or text notifications are safe for the client to be receiving, and the risk of saving a password on a device or computer. And certainly legal advocates can help draft the allegations as well. And then our last screen, this is actually on the AZpoint website as well. These are resources for victims to find a victim advocate, to get help with your case, and then finding additional resources.